Ms Stone.
My Lord, I'm grateful. I was going to move on to the issue of deflecting just before lunch. And one example of that, I say, can be found at C242 of the bundle, which is part of the appellant's evidence. And it's specifically in respect of drug use. And my Lord will see, probably about halfway down the page, the question, so how often did you use that particular drug during that period then? And then my Lord can see the answers, it being unnecessary, the children weren't in my care, I don't have to disclose that sort of information, and then the answers were only given once the learned judge had intervened and said that she was to answer the question and it was relevant. And also on page C240, again, same subject matter, but again I say that the judge was entitled, as her overall assessment of the witness, to consider that she was deflecting when answering those questions at the bottom of the page in respect of drug use. And I also say that the judge was entitled, and that it wasn't because of a lack of understanding or a lack of intermediary or other questions, that the appellant did not answer in a straightforward way when she was asked why she didn't tell the school about the marks on the cheek, and that's C218 to 219, why she didn't respond to the mother's messages, C224, why she didn't tell anyone else about the marks, C225, why she didn't contact the father, who my Lord has probably picked up was also previously a friend of the appellant's, that's C226, and why she hadn't previously been truthful about her use of drugs and her delayed acceptance about telling lies about drug use, that's C226. So I say it doesn't make the hearing process unfair, and I say the judge was entitled to make the assessment of the appellant's evidence that she did. So, my Lord, in addition to those matters I've set out in writing, which I don't propose to repeat unless my Lord wishes me to address anything in particular, I was going to move on to the remaining grounds.
Thank you.
So, my Lord, as far as ground 2 is concerned, and the assertion that the judge was wrong in departing from Dr. Goddard's opinion and giving no reasoned judgment for that, I've dealt with this in writing in paragraphs 31 to 34 of my skeleton. Again, I don't propose to repeat those, but safe to say what I know is obviously well known, the distinct roles of the judge and the expert, which the judge expressly took into account when she said that she had taken into account the expert's evidence and the party's evidence, and of course she refers to and there's no dispute about the principles she applied, the assessment she made of the parents and, of course, the appellant. And in terms of Dr. Goddard's evidence itself, I say that a crucial part of Dr. Goddard's opinion that the judge had to take into account and was entitled to base her inclusions partly in respect of that was the fact that Dr. Goddard was concerned there'd been no report. So at C4 in her evidence, she had said that it was difficult to relate each lesion to a specific incident and said that there was no reporting. She said at C11, her transcript of her evidence, weird and wonderful accidents might occur. In terms of the abrasion on the cheek near the ear, she said it would be helpful if there was a good explanation, but she didn't exclude the possibility of an accident. She said the arm could have been caused by falling into a radiator. If there was a better explanation, it could be accidental. And then she said it's more the reaction that's a concern to me. The lack of explanation puts it into the non-accidental department, and that's C15 to C16. And then again, she went on about the shape, and she said, I've got no solid evidence to say it wouldn't produce that shape. It's unlikely, but it's not impossible. And there are various other references throughout. I can give my Lord more if my Lord wants me to do so. But it's clear she was saying It was the lack of an explanation that really troubled her as a paediatrician carrying out that paediatric overview. But I say, in the circumstances of this case and the judge having to take into account all the evidence, she was entitled to decide that that arm injury was accidentally caused, and she was entitled to effectively draw the inference that there was no explanation for it because of the mother's admitted use of drugs while the child was in her care. So for those reasons I say that she was not disregarding the totality of Dr. Goddard's evidence. She took it into account, and she was entitled to come to the conclusion she did based on all of the evidence. In terms of the mark to the ear, my Lord will see from C31 to C33 of the transcript the questions there were as to whether or not that mark had been there before. But also Dr. Goddard had pointed out in her report, and as I've set out in my skeleton argument, she pointed out that the doctors who had previously examined this child had not noticed any birthmarks, and although it was disputed by the appellant, the examining child protection medical doctor had not noted any birthmarks or anything of the like either. And I say it was clearly within the bounds of a reasonable decision for the judge to come to the conclusion she did about that. In terms of ground 3, and I'm confining my submissions in respect of drug use on ground 3, because
Yes.
that's the finding really that's appealed against, and after some tortuous routes we now have the amended finding 13, and I say
Yes.
the judge was wholly entitled to make that finding for the reasons set out in writing. But in short, the fact that the appellant lied in her first statement because she said she had not used ketamine since before the birth of her eldest child, so some 8 years before, that's D62 of my Lord's bundle. She did not declare any ketamine use at the time her hair sample was taken, that's E4. The results of the hair strand analysis, my learned friends taken my Lord to E6, but E7 is the conclusion, which says on the balance of probabilities ketamine use in that time frame. And there was no application for the author of that analysis to be cross-examined. The appellant did admit ketamine use. My learned friend refers to that as her candid admission, but I say that the judge was entitled to consider all of the evidence about drug use, and chronologically, the admission about drug use came after the hair strand results were filed, not before. I also say that the judge was entitled, as she did in her judgment, and it's at A32, she was entitled to reject the appellant's assertion that she only used ketamine for a short period, in light of her previous untruthfulness, and as the judge said in her judgment, the significant shift in her own evidence, and as part of her assessment of the appellant's credibility. I also say that the judge was entitled to take into account the parents' evidence as part of the whole picture on this, and there was and so that's C137 to 138, C146 to 148, and so she didn't rely solely on the father's admittedly untested evidence, but it was still part of the evidence, and she could take it into account in the context of all the other evidence, as opposed to taking the evidence in compartments. And my learned friend also praised in aid the fact that the judge initially went back and seemed to rely on those historic records, but my Lord will see from the amplification at the end of her judgment at page A32 of my Lord's bundle, the judge specifically says, I attach little or no weight to that. So for all those reasons, I say she was perfectly entitled to make that finding. Yes, A32, my Lord.
Yes.
So where she says, I stand corrected, and then she points out that the appellant, because the social worker wasn't available, had not had the opportunity to challenge it, I accept in the circumstances I should place little or no weight to this evidence. And then she went on and described the evolving story about drug use, as I would put it, and then she said towards about 10 lines up from the bottom of that big paragraph to suggest it, i.e. that she had used the frequency with which she used just for 3 weeks. She said to suggest it is simply incredulous. And I say, as part of the judge's assessment of the appellant's evidence, she was entitled to decide that the appellant simply had not told the truth for all those reasons I've set out.
So looking at that, to suggest it is simply incredulous, I think she means incredible probably, doesn't she? But that's, so you say this, the finding that that the rejection of the ketamine every other day for 3 weeks, that's the sound, you can say that's incredible based on the evidence that was before the judge.
And all the evidence she had, and including the fact that we know on the appellant's own case, she hadn't told the truth. So she effectively, the judge had a foundation that she was entitled to take into account of lies about drug use, and then she considered all of the evidence, and then her overall assessment of that evidence was entitled to make the finding that she did.
In other words, sorry, that finding, you say, withstands the shrunken finding to do with the hair testing.
Absolutely, and because on behalf of the local authority, we suggested the shrunken finding because of this clarification, and that's why it was raised in our response statement, the 3-page response statement. And then the delay only came about because administratively it clearly wasn't put to the judge, I'm afraid. But that's why we say what we say about that finding. In terms of speculation...
Ground 4 then, are we now?
My Lord, we are. And I'm deliberately not repeating what I've said in writing, as I've already said. But in terms of speculation, and the perhaps one key thrust of my learned friend's argument about speculation is in respect of the delay in reporting and the slap mark.
40 minutes. The
40-minute delay. But I say that 40-minute delay has to be put in context of all of the evidence. And I think it was my lady who set out 3 matters. One was that the appellant didn't report it to the school, one was the delay in reporting, and one was the evidence that the judge took into account about the parent's own child not having injuries herself. But I would add to those in terms of there is the evidence that the appellant had previously reported injuries to the school, her acceptance in evidence that she knew school teachers had child protection duties, and she had previously reported injuries to her child and so therefore drew the attention of the school to them, not only before the 20th of January 2020, but also afterwards. So I say that was evidence that the judge had before her and could take into account. And also, yes, it was only a 40-minute delay, but the night before, the minute the appellant had noticed an injury to the arm, she texted the mother and asked her about it and asked her where it had come from. And she, in fact, on this occasion, made no such contact. So I say that even if another judge might not have interpreted the evidence in the same way and might not have come to the same conclusions, that's different from saying this finding was wholly outside a reasonable finding for a judge to make. She was entitled to take the evidence into account. She was entitled to draw the inferences, and I say it was open to her to make.
Well, her case was that she'd been advised by the friend to contact social services.
Yes.
And that's what she did. She spoke to her family support worker.
Yes.
I've just missed a stitch. Can you help me, Miss Stone? Did she in fact get hold of Mother? Wasn't there something about she did in the end get hold of Mother, but Mother was incoherent?
That's what the appellant said.
Okay. Is there any evidence to support that? Do we have any phone messages?
There's no text messages that morning. What the appellant's case was, that because she was asked, well, you sent a text, I'm paraphrasing, you sent a text about the arm, why didn't you send a text about the face? And she said, well, I was going to school and I was just going to wait for her.
She was going to see her at school?
Yes.
Didn't see her at school?
Didn't see her at school.
Then she says that she called Mother and Mother was incoherent.
Yes, I would have to check the transcript, but I do have a recollection. She said she tried to phone the mother, I think she said initially about 10 times, and the evidence was that from her phone records that she didn't.
Okay.
Now, in assessing all this part of the evidence, which is probably the crucial part of the case, or a crucial part, what is the impact of the fact that the judge was unaware about the mother's difficulties? So that goes to 2 things. First of all, the mother's evidence about her difficulties, evidence about what had happened and what she did that morning.
Yeah. In terms of her evidence about what she said happened, I say it's clear from the transcript that she understood the questions and was able to give reasoned answers, clear answers, and for all the reasons I set out before the luncheon adjournment. And in terms of what she did, I say the fact that she behaved in what I would say is a reasonable way the night before with the arm, and the fact that she behaved in what I would say is a reasonable way both before and after this incident in drawing attention of injuries to the school, shows that the fact the judge and nobody appreciated her difficulties isn't fatal to the judge being able to make these findings and to draw the inferences that she did from the evidence.
But she didn't contact the school. She contacted social services 40 minutes later, as she'd been advised to do. She says.
Yes.
It might be said that the 40-minute delay carries quite a lot of weight in the judge's analysis.
I say it doesn't carry disproportionate weight, bearing in mind all the other factors that were before her. And my lord, I started my skeleton argument by, and I know I don't need to remind this court of the pressures that judges are under.
Yes, yes.
And in particular this case, where this fact-finding hearing started on the 4th of January, and judgment was given on the 1st of March. So she might not have set out every piece of evidence.
No, well, my lord, my lady and my lord both have very recent experience of life on circuit and the difficulties that judges at first instance are having. And I'm not so long on the tooth, Mr. Stone, that I've forgotten it. And I hear a lot about it, obviously, for wearing various hats. But clearly, that's an important factor. But nonetheless, it seems to me that's the point you really got to grapple with.
And that's the way I grapple with it, my lord. The child had been home for, at most, the night before 20 minutes when the appellant contacted the mother and said, what's this about?
20 minutes.
The arm. 20 minutes.
So 20 minutes to the mother, 40 minutes to social services.
Well, but in the context of not contacting the mother at all. She didn't make any inquiry of the mother as soon as she saw it. That was her evidence. And I say she couldn't answer why not when she had done the night before, unless there was another reason. So, yes, there's a difference between 20 minutes and 40 minutes. And well, obviously that's 20 minutes. But I say it's the circumstance and it's who she contacted. She didn't, when she got to school, her evidence was she knew it was there when she got to school. So the judge, I say, was entitled to take into account, well, if she knew it was there, why ask for a friend and then go home? And as the judge found, then have time to think about it. Why not? She knew it was there when she dropped not only Jay off, but her older child off. She dropped the older child first, then Jay. She had 2 opportunities to speak to a teacher, and she knew from her own evidence that teachers have child protection responsibilities and teachers get in contact with social services. So I say the judge was entitled, on the basis of all of the evidence, to come to the conclusion, as she did by making the findings she set out to make a case, and inconsistencies in her evidence and so on and so forth, to effectively be playing for time and thinking about what she was going to do.
Wasn't it reasonable for her to ask the mother first for an explanation before she went to the school teacher?
Yes, but she didn't. And that's really the local authority's point. She could, as soon as she saw it, she could easily have contacted the mother and said, what's this? Exactly the same as she did with the arm. But it's the fact that she didn't contact the mother, which I say the judge was entitled to take into account when deciding that she didn't contact her, because in fact she knew very well that injury hadn't happened in the mother and father's care. She knew it happened in her own care.
Going to social services first, before the school, bypassing the school, bypassing the mother, going to social services, is a more, what's the word I want? Not extreme, but it's stepping it up, isn't it?
Yes. It is stepping it up.
So instead of telling the first person who might have taken it on, the school, she went straight to the social services herself after 40 minutes.
She did. And I don't want to repeat a point I've already made. It's the whole point of what she did the night before and what she's done before.
So it's really, I mean, just to try to, This is the point in the case, it seems to me.
Yeah.
It's really the contrast in her behaviour, and it's the oddity of the way she handled what she says was the discovery of the slap marks that morning that led the judge to, you would say, to draw the inferences that she's not telling the truth about it, because there were an aggregation of oddnesses, if I can put it like that. It wasn't what she'd done the night before. She doesn't get hold of the mum in the morning. She doesn't get reported to the school teachers. She says she asks this friend, but then we never get any further on that. Then she goes home. 40 minutes later, she calls up social services. So it's a kind of package.
It is a package, and it's not a package. I know I keep talking about the arm. It's not just a package of the night before and the morning after.
No.
It's a package of what she'd done many times when Jay had injuries, and the court knows there are a whole host of injuries that this little boy had, most of which were accidental, but frequently the appellant, before and afterwards, talks to the school about them, and she didn't.
And that's well documented, is it? That she often had conversations. That is in
With
the
school.
judgment, isn't it?
Yes, it's. I don't think it's actually in the judgment, but there are schedules of injuries where the school have noted injuries to this child and have asked the mother about them, have asked the appellant about them. And in fact, part of the cross-examination of the appellant, which doesn't, I say rightly, form part of the judgment, is the previous injuries there had been and conversations there had been with the school about them, when the school were worried that there were marks to this particular child. And Dr. Goddard was asked about a previous, and these particular bruises aren't the subject of this appeal, but Dr. Goddard was asked about previous symmetrical bruising to shoulder blades. In this instance, they were bruises to the top, but there had been whole discussions with the school about how those had happened. But this time, the school weren't brought into the picture at all. And as I've said, and it was a school well known to her, and not one school, but two schools.
So
That's
So what's the two schools?
the two schools is she dropped the older child first.
They're separate schools, are they?
Yeah.
Okay.
Yes. So although not
schools there.
the subject child, she still had access, and the court also had evidence from Lucy Scott, who was the school teacher, that there would always be a teacher receiving children. So when the appellant dropped Jay off, she would have had face-to-face contact effectively with someone she could report it.
did the school see the bruise? See the marks? Did the school see the marks?
Yes. They saw them during the day on the 20th of January.
After the mother had spoken to social services?
Yes.
But before social services had contacted the school?
Yes, because the social services attended at the school. I don't want to give the court wrong information. It's about 3 o'clock. It's shortly before the end of the day.
And they'd seen, and the school had noticed it by
By then.
themselves?
And I think the chronology, and I'll be corrected by one of my learned friends if I'm wrong, I think that after the appellant had gone home and spoke to social services, either social services or the appellant then contacted the school, and that's how the school found out, and then the school noticed all the marks.
Now you heard my discussion with Ms. Kenny about whether this was speculation. How do you put this?
It's inference. It's inference. It's taking all the evidence into account, and not. We've concentrated on the night before and the morning after. We've concentrated on what she did at school previously and afterwards, but also in her overall assessment of the appellant's credibility. And I say she was entitled to do that. And in fact, the judge says in her judgment there were inconsistencies in all of their evidence.
Yes.
And she took that into account. She said that's part of why her task as a judge determining facts in this case, she found so challenging, because there were inconsistencies all over the place, to put it colloquially. So that's what I say about that. And in terms of inference, and at the risk of repetition, it's of course not every judge might have come to the conclusion that this judge did.
No, and we won't forget that we're not the judges of fact.
No. So that's what I say about. And the other pieces of evidence the judge had that I would just remind my lord of, the fact that the school had said, and the judge refers to this at A33 of her judgment, top of A33, that the school had reported Jay was slightly more subdued this morning, however perked up this afternoon. The judge took into account that the older child hadn't said anything, but also took into account that the older child had made an allegation previously that mummy gets angry with the other child, and the judge took that into account, and my lord can see that at A33. So again, I say it's taking all of the evidence into account, not just the expert, not just the evidence of the appellant and the parents, but all of the oral evidence, and importantly the written evidence. So unless there's anything further my lord wishes me to address on ground 4, I was going to move.
Anything more on ground 4? Okay.
Ground 5, and as my learned friend has already accepted, there is a certain amount of overlap.
Yes, because Kelly rather expanded ground 5 in the course of her submissions.
Yes. In terms of discrepancies, I wasn't intending to go through all the discrepancies, because of my overarching submission is that there are discrepancies in the mother's evidence and the father's written evidence, and I'll come on to his failure to attend to give evidence in a moment, but and in the intervener's evidence.
Yes.
I say that the judge was entitled to, and in fact might have been criticised if she hadn't looked at each injury individually, and I say it wasn't unreasonable for her to separate what was characterised as injury 3, so that's the injuries to
I
the
always
face,
have to get the, yes,
the schedule,
the greatest abrasion.
yeah, on the close to the ear,
Yeah.
and I say she was entitled to distinguish that those injuries from the slap mark, because the parents had specifically said, and by implication the judge clearly accepted this part of their evidence, that they had seen those injuries. So she was entitled to treat those ones differently to the slap mark.
That's what somebody calls the burn mark.
Yes, that's what the mother at one point called
Yes.
the burn mark. And she said it was there, albeit her case was it was there when he arrived. The judge didn't accept the entirety of her evidence, but the fact that the mother and father, in fact, in writing, said they had seen it, she was entitled to treat that in a different category to then what everyone characterised as the slap mark, and everyone accepted on the medical evidence, and all the medical evidence was an inflicted injury, because there was no other explanation at all. And
Yeah.
also I say that the fact that the judge went on to say that one of the injuries to the ear was caused in the same incident that resulted in the slap mark, she was entitled to do that, and the appellant's own evidence, and I've pointed this out in my skeleton argument, was that looking at those injuries herself, the appellant said she could see how they were all caused in the same incident or episode of loss of control.
Yes. So the way things stand, this child suffered a number of accidental injuries in the care of the mother and the father. The mother and the father had a big argument in the middle of the night, in the course of which some act of abuse occurred. The child then goes back to the appellant, and father takes no part in the proceedings. And the judge didn't draw an inference from that.
No, but what she
Did draw an inference against the appellant, as we've discussed.
She did not draw an inference from that Jay was caught in the crossfire. She specifically dealt with that in her judgment, and she said herself that would be speculation.
So Jay had a series of accidents when being looked after by the mother and father over the weekend. It was more than one incident, wasn't it? Then he was present when this altercation took place, acts of domestic abuse occurred. And then he goes, on the judge's finding, goes back to the mother, to the appellant, in whose hands he sustains deliberate injury, an inflicted injury.
Yes. Can I just come back to a number of incidents causing accidental injuries on the judge's findings?
Yeah.
I don't think it would be right to say there are a number of incidents, because, for example, the abrasion near to the ear.
Was there more than one?
It could have been the abrasion to the ear and the abrasion to the arm.
Yeah. Was there more than one incident, or was it?
It could have been one.
It
The
could have
judge
been
doesn't
one.
specify.
But the fewer the number, the greater the more dramatic the incident would have had to have been. And there was no clearly defined incident.
No, there wasn't. The only there was descriptions of play in the park, there was descriptions of play in the woods, of play in the soft play. And
None of these incidents would occur by the child getting distressed.
No description of.
So the child had suffered all these injuries without any getting distressed.
No, that's
Accidentally.
That's right. But then the judge had, as part of her evidence, and she included in her judgment, that in her view, having taken account of all of the evidence, that wasn't necessarily surprising because of the mother being under the influence. And there's one specific incident.
So the child has quite an. I don't mean to be facetious, but the child has an extraordinary weekend. Really, he spends the weekend in the company of this of mother and father. The mother's out. Do we know about the father's drug taking? I'm not sure we do.
We only know about his. Well, the court only knew about his more recent drug taking.
Post the incident.
Way post the incident.
Okay.
End of the year.
So certainly the mother had taken drugs while looking after him. He sustains a series of injuries in one or more incidents, accidentally. He's present during an act of domestic abuse and a big altercation between the mother and the father. And he then goes back to his own mother, at whose hands he sustains an inflicted injury.
But
that's the judge's findings.
It is, but the appellant's own evidence is that she did not see the marks to the face when he came home, and that's part of the evidence the judge was entitled to take into account. That was her case, that she didn't see the slap mark when he got home, even though she changed his nappy, she got him ready for bed, she comforted him, and noticed his face was red because he was crying, and that's in the judge's judgment. So just because it might seem an unfortunate series of events doesn't make the judge necessarily wrong. Because
No, it doesn't.
And however improbable it might sound when one summarises it in that way, I say it was still within the range of reasonable findings for her to make, having heard all the evidence and read the evidence. And she heard the mother and the appellant for, I was going to say days, it felt like days, but there was certainly over a long period.
Yeah.
Because she had the mother in the court, then she had the mother back for a full day, and then in the gap, she'd heard from the intervenor, and then the mother continued, and then the intervenor came back.
Was your case, what was your case at the outset?
Pool.
It was, as the judge found, or pool?
Pool.
So your case was pool and you were testing the evidence, that's what you were doing?
Yeah.
But your case, sorry to interrupt, your case wasn't it, that there had been a deliberate attempt by intervenor to blame mother, and I think the other way around,
So that finding
was so that they were all. Your case was they're all making it up, and actually what happened in the SIFT was the judge accepted one bit of their making it up, and she accepted the bit about intervenor making it up against mother.
Yes.
That was part of your case, wasn't it?
So yes, my case was at the beginning and the end was pool.
They're all lying. Well, there's been so much dishonesty or deception and cross allegation that local authority's case was we can't say who's done it.
Yes.
Your case was. Some of these injuries were inflicted.
Yes, and in fact, I said more were inflicted than the judge found.
Yes, so including the injuries which had occurred while the children were in the mother's care.
Yes,
the child was in the mother's care.
Yeah. And I in both, and I cross-examined both the mother and the appellant on that basis, as my lord says, testing the evidence, and that was the local authority.
Was your case that some of the injuries had definitely occurred in the mother's? Some of the inflicted injuries had occurred in the mother's care. Were you saying?
I said.
The injuries which the judge found in the event were accidental. Some of them you were saying were inflicted. Were you saying, and they must have been inflicted by the mother, or were you saying for all the injuries, everybody's in the pool?
All of the injuries, everyone in the pool.
Okay. But you tested it.
And in fact, even though that was my case at the start and my case at the end, I say that it was within the realms of the reasonable finding for the judge. Just because it might.
You're not tied to your
just
case.
Just because I didn't get what I want.
No, you're not tied to your case
wrong.
in the first instance. That's not how it works.
But the allegation. Sorry to go back to my other point. But the allegation of the cutthroat, that was always part of your case, wasn't it?
Yes, that they
you
were.
You couldn't say which bits were being cutthroat and who was lying about what, but that they were lying to put the other one in it.
Yes, and just by way of example, in terms of lying to effectively put the other one in it, the mother had claimed that she had looked after Jay on many, many occasions, and that was clearly untrue. And I was saying, you're just trying to make it look as though it couldn't have happened in your care. And then, just by way of example, I cross-examined the appellant on the basis, as we've had the discussion, that you didn't report that injury, the facial injury, because you knew very well you'd done it, and then you'd gone home and you didn't report it to the school because you knew, and then it was only when you were advised by a friend that you realised you had to do something about it because it was obvious.
we're on ground 6, and I want to put a slightly different point to you. Because ground 6 is the judge should have drawn an inference from the failure. Another point could be failure of the father to attend.
Yeah.
Another point could be the judge was not in a position to evaluate given the complexities of the case, including the case you were advancing, the judge wasn't in a position to reach a definitive view without the father's participation.
Well, she took into account the discrepancies between between two parts of his written evidence, i.e., his statement and his police interview.
Yeah.
And I say that she did draw. I'm answering the question also taking into account ground 6. She did effectively make some findings against him on domestic violence.
Yeah.
So she was able to carry out that part of her assessment. And I say that it was within her contemplation of all of the evidence, because, for example, the father not being involved in this didn't preclude her from making the findings she did about the slap mark because of what had happened the night before and the morning after. So she didn't actually need the father.
Well, except she didn't have his evidence about what happened in the middle.
No, but she did have his evidence in that his case was that nothing happened between the mother and the father that night, because although he didn't come back for round 2, if I can put it that way, the February resumption of the hearing, he was there throughout round 1, giving instructions, and witnesses were cross-examined on the basis of his case. So his case was clear that nothing had happened that night. But the judge felt able, and I say she was entitled to find, because of the text messages and because eventually the mother's own admission, that there had been an event that night. So I say she didn't.
But it is a big gap in the evidence. The fact that he wasn't cross-examined.
It is a gap in the evidence, but it's not I say it's not a fatal gap in the evidence, because the judge had all the other evidence, and she took into account the fact he didn't appear, and she took into account what he said and what everyone else said about his actions. And she was entitled to say it would be too far to go down a road of speculation that Jay was caught in the crossfire that night. And she had the mother's evidence about that.
Yes, but not so much. I'm not asking really whether she should have found that he was caught in the crossfire, but doesn't the possibility that he was caught in the crossfire remain because the father's evidence has not been heard?
I think I have to accept that remains, and that's part of that whole incident being caught in the crossfire was part of the local authority's position of pool finding. That would have been a reasonable finding for the judge to make, and she didn't make it. She didn't go down that route. But as I said repeatedly,
Your case is on appeal. That's not the only reasonable finding. I notice how you put it.
there's a whole range, and that's why we say she could reasonably come to the conclusion she did.
Right.
But to come to that conclusion, so just again playing with it, that would mean that preferring that it had happened overnight when Jay was staying away would have meant that she would have to find alternative explanations or disregard the oddnesses that we've talked about her behaviour the following morning.
Yes, yeah. And the fact that on the appellant's own case, she did not, although she looked at the face, she didn't see any.
She saw a red face, but she didn't see any marks on it, even though she had an hour with the child before he went to bed.
Yes.
And was looking at his face and spotted other problems and so on. So all of that. So somebody here might have been standing up, arguing the other side and saying that it was the wrong.
And those, as my lady described them, oddities. Yeah. They remain.
They remain.
With or without the father.
And they're not affected by the father's absence.
No.
No. Okay.
But to be pool, those would have had to have been disregarded because, wouldn't they?
Well, for
or
pool,
could have just said, "I don't know."
She could have said there's a real possibility it was mother, father, or appellant.
Those factors would point to it being a real possibility, but the judge might have found, on your case, was they didn't get over the line on probabilities to perpetrate.
Exactly. They might have remained on the list, but she might have decided they didn't make it into the pool.
What can you tell us a bit more? We asked some questions about where we are in these proceedings. So the proceedings regarding this family have concluded.
Regarding S have concluded, yes.
Yes. And the proceedings about J, any further information about that?
Yes, the further information I have, I'm not instructed in those proceedings at
No.
all. But the information I have is that there is a parenting assessment by an independent social worker that is due to be received, I think, next week. The indication that has been given, and that's all it is that it is, if I can put it this way, not negative. But until of course the local authority have seen that independent assessment and filed their own final evidence and care plan, I can't say definitively that it's what the outcome the local authority seeks will be.
So this was so Jay's been at home with Mum with the intervenor all the way through.
Yes, and there was that short period.
But recently.
Yes, recently. Yeah, and I can I just going back on another point in terms of understanding and the whole intermediary point. Of course, the appellant was assessed by Dr. Taylor in June. Yeah. No special measures recommended.
June 2021.
There was no suggestion at that point by the appellant's representatives that there was a problem in her understanding. It's only when the report of Dr. Jocelyn comes in, I think, October or November, that the intermediary
kicks off.
Bus leaves the station, train leaves the station.
Okay.
But yes, so IRH on the 20th of December.
Thank you.
Unless I can assist any further, my lord.
Yeah. Thank you very much, Ms. Stone.
Thank you.
Yes, Ms. Barr.
Yes, thank you, my lord. Your lordship.
Well, you thank you very much for coming into this case at short notice, and but your case follows very much the line of the local authority, doesn't it?
Indeed, my lord. My case on behalf of the mother does follow the line set out by the local authority. My client, from her perspective, she accepts the findings made by Her Honour Judge Nisa, and in relation to that finding 13, she's in agreement with the amendment. And the only issue where I departed company with the local authority is in relation to whether this court should, if the appeal is allowed, simply substitute
A pool finding.
Indeed. And the position on behalf of my client is that should not be the case, because your lordship and ladyship are here to deal with whether Her Honour Judge Nisa made a decision that is wrong. So were her findings wrong? And if you find that is the case, they would be set aside. But from my client's perspective, she, in relation to those findings 1 and 2, the slap on the face has been exonerated. And it would simply be unfair in my submission to make a pool finding in that sort of way at an appeal, as opposed to a rehearing. My lord, I just following on from what the local authority has said and those submissions, I would simply add, of course, your lordship is well aware of the family procedure rules and Part 3A, of course, and dealing with intermediaries and those who are vulnerable. But what I would invite your lordship to consider is looking at the transcript of the appellant's evidence. Is the quality of her evidence diminished by the lack of an intermediary? And I would endorse the submissions made on behalf of my learned friend Miss Stone that they don't, that evidence is not diminished, because the appellant, she had an opportunity to answer questions. She understood the questions. She was fully represented. And of course, it behoved those representing her at the earliest opportunity under Part 3A to have identified any difficulties in relation to their client, which certainly didn't happen. But of course, my lord, I can't.
It's very difficult, you know.
It is.
We've all had experience of not realising, we've been in the position, I say I certainly have, not realising that a litigant who one's been dealing with for some time is in fact has difficulties that one hadn't appreciated.
Yes, my lord, I appreciate it. It is difficult, but one can also look at the length of time. So since at least June 2020, the appellant was joined as an intervenor to the proceedings and was fully represented, and again by the same instructing solicitor, as it were. And as my learned friend for the local authority has indicated, two lengthy and detailed narrative statements setting out her position were filed and served on her behalf. And my lord, just dealing with the point if the appeal were to be allowed in part or entirely, the court, I would invite the court to consider the purpose of a rehearing. As the court is aware, the proceedings concerning my client's child are concluded. The fact finding itself was extremely traumatic for the mother and no doubt as it was for every party, but for her to have to then, having been under the expectation that she'd given her evidence over a series of days and separated over a period of time, that those proceedings were brought to a head. The fact that she may have to relitigate all of that again must be extremely disproportionate in my submission for her to have to go through that.
What order? Remind me what order was made in respect of her child at the conclusion?
It was a special guardianship order, my lord. As indicated, I didn't represent the mother at the fact-finding hearing or indeed at the final hearing of the proceedings, but I understand that her child is with a family member under a special guardianship order. But of course, to place my client within a pool finding in relation to allegations 1 and 2, of course, would have potential future implications.
The contact.
Indeed.
What contact is she having with the child at the moment?
My lord, I haven't had an opportunity to take instructions from my client today, so I would defer to the local authority in relation to that.
Is it supervised?
Can I just have a moment, my lord?
Yeah.
My lord, we would need to give an accurate answer. We would need to have a look at the system, but it always had been previously.
Yes.
Given my knowledge of that case, I'd be surprised.
Okay, all right.
Well, there you have it, my lord. If her contact is supervised, of course, there would be future implications and repercussions in relation to amending that finding in relation to my client when she potentially applies for unsupervised contact or increased contact or anything along those lines in the future in respect of her child.
Okay, so if we were to allow the appeal by today, you would invite us not to substitute a pool finding. So the alternative would, rather than remit for a definite rehearing, remit to, say, Judge Rayside to decide whether there should be, what further hearings there should be. And it might then be regarded as unnecessary and disproportionate for there to be any further hearing.
Indeed, my lord, that is a possibility.
And of course, that might coincide with a similar. I mean, if the assessment is as positive, no, I won't say positive, not negative. Let's be more positive. Positive. At the end of the day, so far as the intervenor is concerned, then there might be no further. It might be disproportionate to have any further hearings in those proceedings as well.
Yes, indeed, my lord, that is a possibility, and of course, bearing in mind the criteria, I believe it's in Re the President's decision on proportionality of fact findings and
yes,
sort of matters, and of course separate fact finding hearings as opposed to composite hearings. The point was made about the father not being present for the second tranche of the fact finding hearing, but of course. It was open, in my submission, it was open to those on behalf of the intervenor to seek a witness summons for him to attend. As I understand it, he attended for a full 5 days. He then indicated for the second tranche he was having difficulty with an employer and taking time off work, but no means, as I understand it, was sought to ensure his attendance if that was felt to be so crucial. But I do endorse what Ms.
Is he having contact with the child?
Again, my lord, that is not information that I have within my knowledge, but the local authority may be able to assist. I would certainly defer to them. Of course, I don't represent the father,
No,
and I really do not have any information in relation to the father or indeed his position in respect of this appeal.
Thank you. Is there anything else you want to say?
No, my lord, unless there's anything further.
Thank you very much, Miss Barry. Thank you again for coming in and helping us
Thank you.
at short notice. Okay, Miss Kelly, what do you want to say by way of reply?
I'm grateful, my lord. Thank you. I just have one or two areas to reply to, and I'm going to go backwards in the order in which they were raised. Both my learned friend for the local authority and the mother have referred to the appellant having provided lengthy, detailed narrative statements in these proceedings. And what I say in respect of that, sitting with her solicitor either on the telephone or via a Zoom call and telling her version of events is very different, my lord, from interpreting evidence, questions, and understanding what is behind the question and how you answer it. And for that, I say it's a very different. Reliance shouldn't be placed on the fact that there are some detailed statements as to mother's understanding. In terms of concerns raised in respect of the appellant's cognitive difficulties not being raised until after the psychological assessment, that's not quite right, my lord, because the assessment of the mother, of the appellant, her parenting assessment is indeed a PAMS assessment, and there was a specific hearing to deal with whether or not that would be a PAMS assessment. Initially, it was resisted by the appellant, and again, I say that resistance is indicative of a degree of understanding. In terms of the incidents that were the accidental incidents, from my recollection, there were three. The mother records falling off of an ottoman when R fell on top of J and landed on his face. The mother records a further incident jumping on the bed, falling off and hitting the radiator. And then we have the fall down the bank, the path, or whatever other way it was described by the mother. So there was three incidents in that period of time. Also, my lord, in terms of who the mother reported the matter to, she reported it to social services, but she then did herself call the school. And that is apparent in the documents. The school acknowledged that when they'd noticed the injuries and were going to make their referral, they'd already received that call from the mother. From the appellant. So she notified social services. She made that first call at 9:40. It's not right to say she didn't contact the mother that morning. She did. I've already outlined her position in respect of why she didn't initially call or text. She wanted to go and see the mother outside of the school and get her view. But she did then call the mother, and she was cross-examined, as my learned friend Miss Stone said, in respect of her telephone calls, that there weren't as many as she thought, but there was certainly two. And off the top of my head, I recall the first one was about 10:10, and then later, I think it was in or around 10:30, 10:40, when the mother was at a doctor's appointment. So she did make those efforts to contact the mother. In terms of, and it's my last submission, in terms of the slap mark and the totality of the evidence and what is said about Her Honour Judge Nisa being able to draw that inference because of those oddities, as it has been put in terms of what happened that day, I draw the court's attention to it's H47, where the mother tells the police that that Jay came off the bed. He didn't cry, but he was going and the police officer clarifies with the mother that she is holding the left side of her face, and the mother at that point says his whole face was red, and that accords with what, of course, the appellant says.
The mother, are we on the mother or the appellant here?
No, the mother in her police interview says that is what's happened. He had a red face. He was saying, and I say that accords with what the appellant said, that he had this bright red face. And again, at H47, that the mother tells the police officer that it could have come up the next day because it takes time to come out. So I say, on behalf of the appellant, there's a clear indication in the evidence that something happened to Jay's face and that the mother was aware of it, and she didn't make it known, and she wasn't consistent in her evidence. She said she didn't see it, then she did see it, then she didn't see it. And on that basis, I say, as I said in my previous submissions, that the evidence base is not there for the learned judge to have made the finding that the appellant caused the injury.
Thank you.
Well, unless I can assist further.
Anything else? Thank you very much. Well, we're very grateful to all of you for your written and oral submissions. We're going to reserve our judgment. If possible, we will try to ensure that it's handed down before the IRH on the 20th of December, but I'm afraid I can't make any promises about that. When the judgment comes out, it will come in, first of all, in draft to counsel. That will be the opportunity for you to make any corrections on typo errors or minor corrections of fact. It's not an opportunity to re-argue the case. All right? We will then, when we've got your corrections, we will then hand down judgment. That will be done remotely under the COVID protocol. No need for you to attend, but you will be asked to agree the terms of an order reflecting our decision.
Okay.
Thank you very much.